Why is it that the Trump administration is changing so much for them and impacting them in such a negative way when his entire campaign promise was about stopping illegal immigration, blocking people from coming in at the border unlawfully? We'll also talk about the latest on layoffs for those that are in H-1B status in the 60-day grace period, what options are available right now. And lastly, in response to this memo on adjustment of status that came out about 2 weeks ago, why officers at USCIS interviews are asking questions about consular processing. What questions are they asking? What kinds of requests for evidence we're seeing, whether we're seeing approvals. Has anyone received denials after this memo? So we'll give the latest update on that.
With regards to the F1 regulations, Emily, we've been telling that it's forthcoming, most probably by the academic year. I'm expecting by end of August or even before August, or probably the effective date will be either August or September. They will be having new regulations with regards to it. F1. Normally, people who come on F1 visa, let's say, for example, they want to do a bachelor's degree in United States. After they do the bachelor's degree, then they can get an OPT. For that, they will apply a I-765 form. And for later on for the STEM extension, after they get the employers, after the employer fill the form, they submit the form to the DSO, get the I-20 endorsed, and they file another I-765 form. And both I-765 forms could be filed in premium processing to get the approval. What are the new, and same thing with master's degree too. And normally they are given 5 years of visa stamping, and that doesn't mean that they can only stay up to 5 years in the country, based on the duration of the university and also on the OPT STEM extension. And sometimes, let's say, for example, they want to do a particular degree and they decided to change and they want to add another degree, they could also do another degree, and that may take a longer time. They were allowed, they had that flexibility previously of moving from one university to another university sometimes, or within the same university, doing more courses. Now, what are the restrictions that are expected to come in this August or September of 2026, Emily?
Yeah, so based on the proposal, as of right now, USCIS is not involved in most actions related to F1s. They're only involved if you file a change of status to F1 or reinstatement if you fall out of status for some reason, or your OPT and your STEM extension. That's it. Everything else is done by the DSO or through the consulate. Going forward, what we expect based on the proposal is that when you first enter the US on F1 or apply for that change of status, instead of being issued an I-94, an end date of duration of status, which allows you to be continued to be found in status as long as you are attending your classes, now you're going to get a set end date. That's either going to be the length of your program or a maximum of 4 years. So if you're coming in for a bachelor's degree, you'll get an end date that matches your program end date on your I-20, 4 years after you start. If you are coming in for a master's program, you'll get a 2-year I-94. For a PhD, it's still only going to be 4 years, even if that program goes well beyond 4 years. What do you do when you hit that limit on your I-94? Now, if you want to change your school, if you want to change your program, if you need to defer your graduation date to continue your studies longer, all of those things require a filing with USCIS. We assume that that's going to be another I-539 application, which is the same form that you would use to change status to F1. It's the same form that H-4s and L-2s use in order to extend their stay. So now we have to file another application with USCIS. We already know USCIS processing times are getting worse. We don't know if there will be any premium processing available. I can only imagine the number of applications this is going to add to USCIS's caseload. In the proposed regulations, they said that this is going to cost roughly $390 million from extension filings. So how many cases is that when each application is $470? That's a lot of applications that USCIS is not going to have the time to process. If they don't have premium processing, When you're filing your OPT, you have to extend your program by 1 year, file an I-539 along with it. How long is it going to take them to process the I-539 in order to approve the OPT? We already see that problem with H4s and H4 EADs, that they don't approve them together. They take forever to process, and you're sitting waiting to be able to start work after you've graduated. And so this is just going to delay things further. Same thing on the STEM extension. Yes, you get an automatic 180 days to continue your OPT time, but what if the I-539 filed with it takes more than 180 days? Are they going to approve the STEM OPT without approving the I-539? I doubt it. People are going to lose their jobs. So those are some of the major issues. Another one is that once you complete your program of study, in order to continue school, you have to go up to a higher degree level. You cannot do a second program at the same level or a lower level. This will impact people who have been taking advantage of these day one CPT schools in the event that they were not selected in the H-1B lottery and they ran out of OPT time. That's not going to be an option anymore to do a second master's degree. You're going to have to go up. And then what happens when you finish your PhD? There's no other higher level that you can do. So that pathway to get to an H-1B with the lack of visas in the lottery process is going to drastically impact people who've studied here, who we want to contribute their the skills here that they've gained and not go abroad and compete against us. Instead, we're going to be forcing them to go abroad because they're not able to get switch over to an H-1B.
Are you sure that 180 days is going to be there when the new regulations come in?
I don't know. I don't know how they could, because that's exactly why they eliminated the H4 EAD automatic extension, or the way they had it set up was so hard to work with, because they said that they could only give you the automatic extension when it existed if your H4 I-94 had already been extended. That's the same thing they're going to say with the F1. We can't give you the 180-day automatic extension because your F1 extension hasn't been approved yet. So yeah, I do think there's a risk that the 180-day auto extension will go away.
Emily, right now, when we are going for OPT, practically no documentation is required. I mean, you just file I-765. You just say that you completed your degree and you're going to get an endorsement of I-20. You have to file within 30 days of the endorsement, and you get an EAD, no questions asked. When these new regulations are going to come in, what restrictions do you anticipate coming in?
Yeah, I mean, I think up to this point, no questions are asked by USCIS, but people do have to prove that they qualify to their school, to the DSO, otherwise they won't receive an I-20. Now USCIS is going to be second guessing that and asking, have you properly maintained your F1 status up till this point? So you may have to provide your transcripts, your degree certificate, of course, all of your I-20s. They could. Remember, extensions of stay are discretionary in the eyes of USCIS right now. Could they decide that because you had a law enforcement interaction 4 years ago while you were doing your bachelor's degree and you were, under 21 years old, and you did something stupid because you were a kid, could they decide that you don't deserve discretion and therefore they can deny your F1 extension when you're applying for your OPT? I think they would try it. Could they deny it if you're subject to some presidential proclamation? They're already doing that for OPTs. Why wouldn't they do that for the F1 too? What about the travel, not the travel ban, the USCIS benefits pause? They're already pausing OPT applications for people from certain countries. Of course, they're going to pause the I-539 on top of it. What if they just don't like whatever is in your background? They could choose to deny the I-539 on those grounds. So I do think there's, especially for people who've been on F1 for some time, done program after program after program to stay in the US, likely will not be able to get those extensions when it's time.
There are a lot of questions coming on, especially from Harsh Shah. What happens to those people who are in the second master's degree right now? I don't think so it's going to be any problem for you to complete the second master's degree. However, the restriction, what I'm expecting it to come is when you're going to apply for the if you have already completed the OPT and STEM extension, then that's fine. You are not eligible for OPT because you already have one master's and you're going for second master's. But I'm expecting that they will allow you to complete the second master. That is what my expectation is. Emily, please correct me if I'm wrong. For those also people who are on student visa right now, what are the restrictions they will face? Definitely, if when they are going for OPT, as Emily has pointed out, you may have to file the I-539, and we said what are the restrictions that may come up with. They may also come up with take away the 180 days auto extension for the STEM extension. They may also want you to file an I-539. Now, what restrictions they are going to put on top of just filing an I-539, I-765? Do you need to have a job offer at the time when you're filing the 765 application? And I-539 OPT, we don't know yet because it's like a chicken and egg. Unless you have an EAD, employer is not going to give you an offer. And unless the and USAs may not give you the EAD unless you have an offer. It's like a chicken and egg issue. That's going to be a problem. Emily, can you correct me that how the people who are already in USA, already on F1 visa, how will it affect for them?
They did say that there will be transition provisions for people already in the US who have duration of status on their I-94. They did not specify exactly what that transition would be, but I do believe they specified that if you travel after the new regulation comes into effect, when you return, you will no longer get the duration of status, even though you were in the US at the time the rule took effect. So I would say don't travel if you have duration of status after this new rule takes effect. But beyond that, what is the transition going to look like? Are you going to be able to keep that duration of status? What if you go into a new program? How is that going to happen? Nobody knows yet. It'll all come out in the final rule.
Anything else, Sandeep, before we go to second one?
Oh, we can move forward.
There are a lot of rules, regulations that are changing from since the time this administration has come in. Nothing good came out from this administration, I would say. They have stopped the drop box. They have restricted the amount of visas that people got. They have done the social media vetting process to delay the entire stamping process. They have canceled the visa stamping appointments. They are now wanting to change the F1 regulations. They are already issued a memo to change how the adjustment of status work. The H1B to B2 back to H1B was something that we used to do it very regularly. USCIS have issued a statement in the website, and now they're reversing back on that one. And we have also seen people who are getting laid off when they file a B2, switching back to H1B is becoming almost impossible right now. Emily, what do people need to do to, the rules exist right now, and we tell people, hey, these are what the rules are. You follow the rules, you'll be fine. And then now you turn back and say, yeah, maybe I told you that, but it's not right. What do people need to do?
Yeah, we kind of have to predict the future a little bit and think about what we think the rules might be, even if they're not the rules today. And you can predict the future based on Project 2025, Heritage Foundation. This is literally step by step everything that's in Project 2025 when it comes to immigration. They're taking the USCIS benefits adjudication model and turning it into a screening, vetting, wage protection, and enforcement model. They want USCIS to operate as a screening and vetting agency, more emphasis on eligibility, fraud detection, national security, public safety. They want the employment-based system to be completely turned into a merit-based immigration system, get rid of the diversity visa lottery, end chain migration, use H-1Bs to be an elite program. Where do you think the $100,000 fee came from? Because they only want people that are worth companies paying an extra $100,000. They want the wages to be increased. Heritage Foundation wanted to eliminate the ability to use level 1 and level 2 wages completely from H-1Bs and perms. Instead, they just moved up all of the wages in the proposed regulation that they're working on becoming a final regulation, limiting the classes of people eligible for work authorization. We know they've already eliminated, TPS for lots of countries, eliminating automatic extensions of EADs for most categories, turning the State Department into vetting and screening rather than facilitating travel and facilitating business, using visas as a way to leverage policy, foreign policy, and how they want other countries to act. All of these things are straight out of Project 2025. So if you want to know where things are headed, you can read that and try to predict the future. I think it's a good idea for any immigrants in the US to figure out what your backup plan is going to be, whether that's a different visa category if something happens, whether that's a different country if something happens. What are you going to do with your house? What are you going to do with your car? What are you going to do with your lease? What are you going to do with your dog? Have these plans in place. What are you going to do with their kids if you're US citizen kids? Unfortunately, that's what legal immigrants have to think about right now. It's not just undocumented people that have to worry about these things anymore.
Well, we have seen technology employees part of the dot-com revolution in 2000. I have seen that. And I've also seen the 2007 to 2012, where we have seen a lot of improvements in the cell phone technology and internet technologies, Internet on Things that came out between 2007 and 2018. And somewhere in 2021 or so, we have seen the artificial intelligence. I mean, which is a bright thing that came out, and definitely the immigrants were part of it, and they used to bring the brightest, even though the overall things are not good. Inflation is high, interest rates are high, the oil price is very high. Yet the stock market in United States is doing extremely very good, thanks to all these information technology people, because all those old companies that were existing, for example, ExxonMobil, GE, and all those things, they don't even appear in the top 50 companies of the world anymore right now, which they used to be top 10 companies of the world. But it's right now Google, Apple, Tesla, and Nvidia. These are the companies. They're all technology companies. Thanks for all the people. And these are the people that were part of the revolution. Now, the government is turning against them and then kicking. Previously, they were trying to bring the brightest and the best in the country. Right now, they are trying to throw them out. That's all I can tell you right now. The only thing you guys can do is just follow us regularly every week, because we give you very fresh updates what's going on. We put a lot of effort on that. We also have a daily Zoom call. We strongly recommend, because this is all what we are telling. You don't know what the other people, what our clients are telling. I mean, what the prospective people who are in the immigration field. We have a daily conference call we've been conducting from past 14 years. Almost 70 people come in. We want you to at least come once a week or once a month and spend about half an hour there, because you will get to know what the other people are speaking, what the other people are facing the problems, so that you can know that how to plan yourself in the future. Because sometimes we tell you what to do, but when your own colleague tells you what to do, what's happening with him, you will trust them much better. You will understand, because you're in the same shoes as that person is. Because we are not in the same shoes as you are. We are lawyers. And you are in a non-immigrant visa. So definitely, we strongly recommend you to come for the daily conference call, and the link is provided at the bottom. Emily, with regards to the layoffs on the 60-day grace period, that the artificial intelligence revolution has also brought up a lot of layoffs in the companies. We have seen a lot of hirings in 2021, 22 after the COVID, because the technology revolution happened. And then it brought in the artificial intelligence, which is eliminating some jobs at this point of time. When does the 60-day grace period start? Is it on the last day of the employment, or is it on the last day I get paid? Now, I see two kinds of companies. Some of the technology companies, Emily, what they're telling is that even though you got laid off on May 31st, you're technically considered to be our employee until July 30th. and you will get paid until July 30th, and we will withdraw the H-1B on July 30th. Those are some of the things that I see in the technology companies, which normally they treat the employees much better. But when I look into financial companies or the insurance companies, they will say that your job is terminated on May 31st, even though you may get paid for that period of time, you will not be considered an employee of the company. Tell me in these two scenarios where they are considering them as an employee, but the last employment is still May 30th. Tell me in these two scenarios, when do you start counting the 60 days of grace period? Everybody knows that once they get laid off, the I-94 validity is there. They get to have 60 days. Within 60 days, say that they have to move to a different job or probably move to a different status or move out of the country. Everybody knows that, but they need to know when the 60 days starts.
Yeah, and the difficulty is we don't have any specific guidance from USCIS about whether severance time counts, even if you're considered to be an employee, but you're not working. Are you maintaining your status if you are being paid but not working on a garden leave or something like that? The regulation that created the grace period just refers to a cessation of employment. Does that mean cessation of paid employment? Does that mean cessation of job duties? We don't know. I do know that they are looking at it much more closely now than they ever have before. I recently dealt with a case where they had the paycheck dated a certain date, but the pay period ended before the paycheck. And so USCIS is using the last date of the pay period as the end of employment, not the date of the paycheck, even though the former employer had even provided a letter confirming that that person was still considered an employee for X number of days after that pay period. They were on unpaid employment and they were still receiving insurance benefits. The employer provided a very detailed letter about that. USCIS said, don't care, you're not working. Your paycheck says your last date of pay was X, therefore that is your cessation of employment. That's when we start the grace period. And you have to be really careful with that, because if they find that you filed after the grace period ended because they started it sooner than you expected, it can trigger the $100,000 fee. They convert your H-1B to consular processing. So in my opinion, it's better to be more conservative on that, be safer, go by the actual last date that you did work, and take some action within 60 days of that date. Don't rely on the severance pay, especially if it looks different on your paycheck. I think it's just safer to go by 60 days from the day you stopped working, stopped doing active duties as an employee. Have you seen any different takes on that?
When I'm seeing the paycheck, when they say that the company is saying that the person is considered still to be employee of the company, and on the paycheck, if they're receiving the paycheck as a regular pay though, I am not having problem to use the July 30th as where the 60 days starts, Emily, if they're getting paid regular pay. But if the paycheck says it's a severance pay, definitely that is going to create a problem. The other thing I'm noticing is that the companies, especially the technology companies, let's say they got laid off on May 30th and July 30th is the day they are telling is the last day of employment. They are clearly demarcating, saying that we are going to withdraw your H-1B on July 30th. In that, and the paycheck still says that they're getting a normal pay. In that particular scenario, I would consider July 30th as the start date for the 60th day. Let's move on to the fourth topic, Emily.
All right. Yeah. So with this USCIS memo reminding officers that they have the discretion when adjudicating adjustment of status, they came back a little later, tried to walk it back a little bit, claiming that this doesn't impact most people filing for adjustment of status. It was just a reminder to officers of the discretion they already knew they had. But how are we seeing this play out in the real world in actual adjudications? Have you seen any approvals of 485 applications following this memo coming out on, what was it, May 21st, if I recall?
I got some approvals for the family-based even without interviews after May 21st. It could be that they already made a decision, they have already approved it. I have been told by the people who come to the daily Zoom call that they've been asked, why did you apply for the 485 in United States instead of applying the adjustment of status, instead of applying the adjustment of status in your home country, though. I haven't seen any denials at this point of time. I've only heard a rumor of one RFE at this point of time. Employment-based cases seems to be going smoothly at this point of time. Family-based cases, we will have to see how it's going to work out as the things progress a little bit more, because by the time this memo sinks into the skin of the USCIS officials, it may take a little bit time. Now, you know how our government officers are. Our clients probably will read all these things much better than the government officials are. It may take for them to sink in. So definitely there are some people who are consulting me and I'm telling them, hey, hold on, wait, unless it's something very important for you right now, do not consult me until the end of this month. Probably in July, we will be able to clearly tell you how the things are going on. Now, for those people who are going for the interview, Emily, I am trying to draft them a memo saying that, look, uh, like one of the, gentlemen filed for his father. Then he said that his father has a some X amount of dollars in his bank account there. He has a house there in India, which he intends to sell all of those things to bring out here. I told him, take the evidence of that thing. He has only two children and two children are in United States, and his advanced age of 75 years, it's very hard for him to go back outside the country. That's the reason he decided to change. So I drafted a memo for him to take it with it. And I'm doing it for every of my client right now so that they can take it with them and show it to the USCIS official why they want to do they wanted the additional status. We will come to know more comprehensive results by the end of this month, and we will be able to give more guidelines in July first week, though. Unless you have something that the interview is going on right now, I would, I would pause and get the more detailed information in July. But if the interview is going on right now to July, though, I would definitely have all the things that why do you need to get the green card in the United States? Be prepared to answer the question after speaking and having a consultation with an immigration lawyer.